Good afternoon to all participants in the online public hearing organized by the Independent Evaluation Commission for assessing the integrity of candidates for the position of member in the self-administration bodies of judges and prosecutors pursuant to Law Number 26/2022. I hereby declare this session open. This hearing involves the resumed evaluation of Mrs. Marina Rusu, candidate for the Superior Council of Magistracy, judge at the Cahul District Court, Taraclia Office. I would like to welcome you, Mrs. Rusu. We are here to conduct an online public hearing in the context of the resumed evaluation process aimed at assessing candidates for the position of the Superior Council of Magistracy. The Commission is acting in accordance with Law Number 26/2022 and its rules of procedure. On the screen in front of you, you have the four members of the Commission: Victoria Henley, Desaripchevsky, Nora Tsotsoria, and myself, Herman van Hebel, the Chair of the Commission. The Commission is assisted by members of the Secretariat, and the online public hearing can also be followed by representatives of the media and the public. During the hearing, interpretation between Romanian and English will be provided. To allow for accurate interpretation, I would kindly ask you to speak clearly and slowly. Furthermore, the proceedings are being recorded and the public parts will be available online generally within 24 hours after the hearing via the website of the Commission, www.vetting.mb. I will start with a brief overview of the procedural background of this resumed evaluation. On 27 January 2023, the Commission issued a decision in relation to your integrity evaluation for the position of member in the Superior Council of Magistracy. In its decision, the Commission decided that it had serious doubts about your compliance with the criteria of financial and/or ethical integrity in relation to two issues. Issue number one, failure to submit the declaration on assets and personal interests for the period of 2014 to 2016, and number two, delays in examining 16 requests regarding the conditions of detention. On 13 February 2023, you appealed this decision to the Supreme Court of Justice. And on 29 January 2024, the Supreme Court of Justice annulled the Commission's decision and ordered a re-evaluation. On 9 February 2024, the Commission started the resumed evaluation, and on 11 June, pursuant to Article 19, Paragraph 1c of its Rules of Procedure, the Commission sent you a statement of facts and serious doubts. On 25 June, you responded in writing to the statement of facts and serious doubts, and on 17 June, you informed the Commission that you wish to participate in a public hearing. During this hearing, the Commission will take into account your privacy and, where required and possible, the privacy of your family members and close persons. So we will leave out unnecessary details relating to, for example, ID numbers, bank account numbers, addresses of real estate, and the like. For the protection of your own privacy, we ask you to do the same. The present hearing takes place at your request. The hearing will be focused on the statement of facts and serious doubts that the Commission has sent to you and your written response to those statements of facts. I will briefly explain the procedure for today's hearing. For each issue included in the statement of facts and serious doubts, you will be given, if you so wish, a maximum of 15 minutes to briefly provide additional explanations to complement your written response to the statement of facts and serious doubts that you submitted to the Commission. One or more members of the Commission may have questions for you about the explanations you have provided, both in writing and during the hearing. I urge you to be concise in your explanations and answers, and I urge you to answer all questions truthfully and completely. Your explanations are obviously important to the Commission in verifying your financial and ethical integrity. I would like now to hand over first to Nora Tsotsoria to lead the discussion with you on the statement of facts and serious doubts. Nora, you have the floor.
Thank you. Greetings, Mrs. Rusu. On 11 June,
Just hang on. I think
okay.
the candidate would like to. And Mrs. Rusu, you have the floor. Go ahead.
Before beginning with the hearing, I'd like to say that actually I have a recusal request sent to the chair of the commission, Mr. von Hebel. And taking into account that I sent another recusal that was not accepted, so it was a request about the reputation of the chair, and currently I have other grounds or reasons according to which I don't have much trust in the commission, and I'd like to express them in the following 5 minutes, and I'd like for my request to be taken seriously. We have a very long process for the justice system in our country, and this is why I kindly request you to take into account all those arguments presented by me very carefully and with due seriousness. Mr. von Hebel, you in 2023, if I'm not wrong, gave an interview to a journalist, to a Dutch journalist, and it was an interview about the preventing process where you are the chairman. And I'll quote what you said in that interview. There are judges who have a lot of integrity here, but also individuals who put their own interests before combating corruption and the quality of justice. Fortunately, the President Maya Sandu and the Ministry of Justice are committed to strengthen the rule of law. This is not the only quote, and in this quote, but also in other words, you expressed some positive words about the president and the ministry. But this reform, this preventing process, has to be an independent one, independent from political parties, independent from different political opinions. I see this quote and I see your publicly expressed opinion as a loyalty to the government party and to the president, Maya Sandu, who is associated in our country with the government party, because we all know that she was the president of the government party, and this party was the author of the reform. It is very important to maintain this perception that the pre-vetting process is a fair, non-political, independent process. So I think my request has to be examined, and it is very important for it to be examined pursuant to Law 26 that says that pre-vetting commission members should be independent. I have a question, Madam Rusu.
Yeah, Mrs. Rusu, yeah, I see two members of the commission raising their hands. I would like to ask first Mrs. Rybczewski to make a comment, and then Victoria Henley, and then we may proceed. Nadia, you have the floor.
Da, eu am vrut doar să precizez
Yes, I just
că
wanted
dumneavoastră
to
ați
clarify
transmis
some
comisiei
aspects.
această
When
cerere de recuzare.
did you send this recusal request to the commission? This recusal request I express
Da, dumneavoastră ați
verbally
întrebat
right now.
membru, nu?
But did you read the regulation, the rules? Yes, I did. And I know that this request should be done in written form, but I was not able to do this in due time because I saw this interview last night and I translated it. If you allow me and give me the time, I will send it in written form. But this is a procedural aspect. I just want you to understand that this perception is driven by facts. And even though you reject my request, this perception remains. And it would be good for you to have an explanation, an honest and plausible explanation. Perhaps Mr. van Hebel had something else in mind.
I would like to give the floor to our member, Victoria Henley, first. Victoria, please go ahead.
Yes, just as a point of order, recusal motions are required to be submitted in writing at the earliest possible time. Canada did not submit this request in writing. I would suggest that we proceed with the hearing as scheduled, and if she wishes to submit something later, we can consider that. But there is nothing before us in writing. We have nothing to look at or examine, and I don't believe it's appropriate to be arguing this at this point.
Okay. No, and I think if the other members, if none of you agree, and I also agree, then I would suggest, Mrs. Rusu, that feel free to submit the request in writing, and then the commission will take into consideration your request, will carefully look into the arguments presented and take a decision on that, and then whatever may be the outcome, the procedure will then continue. So let us go back then to the hearing. Very briefly.
Sorry, I have a question. The member of the commission I don't trust, and I expressed my lack of trust. Should he participate in this hearing? Do you think it is ethical for him to continue to participate? Because I express my lack of trust towards you, and is it okay for you to continue to participate in this meeting?
I assume that you have studied the rules of procedure of the commission, and in its rules of procedure, Article 10 related to conflict of interest is exactly laid out what the procedure is in cases of a recusal request. And in particular in paragraph 3, and I may quote, in case a call for recusal of one or more members would undermine the quorum as per Article 11, paragraph 2 of Law number 26/2023, all members take part in the consideration and decision of the recusal. If the affected members are not required to participate in order to maintain the quorum, the decision on recusal shall be made by the members of the commission outside the presence of the affected members. The quorum is 4 members, as you see in front of you. This means that, and we have 4 members, as you see. This means that I will participate. And of course, I will also share my comments about whatever you may bring to the attention of the commission. And of course, I will carefully leave it as much as possible to the other members to lead the discussion on which direction the decision should go. And that is, therefore, we will entirely take any decision in accordance with the rules that we have established. And as I see from you, you have been studying as well. Then I would like to give the floor back to Nona in order then to continue with the hearing. Nona, you have the floor.
Thank you. On 11 June 2024, the Commission sent you a statement of facts and serious doubts in relation to 2 issues. 1, failure to submit a declaration on assets and personal interests for the period of 2014-2016, and incoming and outgoing financial flows of the candidate and her family for the period of 2014 and 2016. And the second issue, delays in examining 16 requests regarding the conditions of detention. In relation to the first issue, and let me remind you, It's a failure to submit a declaration on assets and personal interests for the period of 2014-2016 and incoming and outgoing financial flows for the same period. The Commission provided you statement of facts and formulated its doubts as follows. The Commission has serious doubts about the compliance of the candidate with the criterion of financial and ethical integrity with respect to failure to submit in 2017 a declaration on assets and personal interests for the period of 2014-2016 as required by the law. Because the National Integrity Commission had existed since 2013, and new legislation related to the declaration of assets and personal interests was adopted in 2016 that had been debated publicly since 2015, the candidate should have been aware of the basic rules on submission of declarations of assets and personal interests. Thus, the issue concerns only one declaration covering the period of 2014-2016. Based on information submitted by you before the Supreme Court of Justice and collected during the resumed evaluation, the Commission was able to verify your and your family's income and expenses for 2014-2016 and concluded that during these years, your income exceeded your expenses. Thus, you mitigated the Commission's doubts about your financial situation during the period 2014-2016. If you so wish, please briefly provide additional explanations to complement your written response to the statement of facts and serious doubts. As just indicated, you are provided a maximum of 15 minutes to further elaborate on this issue. Of course, you don't have to use these 15 minutes. Mrs. Rusu, floor is yours.
Da, mulțumesc.
Thank you.
Referitor la acest dubiu,
About this doubt,
vreau să menționez
I want to mention
din mai multe decizii, chiar și în decizia
in
privind
several decisions,
nepromovarea evaluării în privința mea,
including in the
Comisia a
decision
menționat că simplu fapt
to
nedepunerea
fail me,
declarației
the fact
nu
that
prezintă dubii de integritate.
I failed to submit a declaration of assets, it does not represent doubts regarding integrity. So, a decision of the Supreme Court of Justice annulled this decision of the Commission. And in a CSJ decision, it was found that when a judge did not buy, during that period of time, a house, a car, did not spend money on a big expenditure, on a big purchase, but all the expenditures that were calculated, in my case, using the minimum consumption basket for the population, cannot present a doubt for the Commission. The minimum consumption basket is insured if the person is still alive. And in my situation, in the table with all these alleged expenditures, living expenses for me and my children, I had 5 children back then, 4, and then the 5th was born. In that period of time, I had 2 newborns. And up before 6 months, so between 0 to 6 months, I breastfed them, which means that there is no way to include for a minor expenditures for hotels, for tobacco, for alcohol, that according to the used calculation, the calculation used by the Commission and developed by the National Bureau of Statistics, have been included.
Комісія, știind având
The
informația
commission
despre
had
aceste
information
circunstanțe
about
personale și
my
familiale,
personal and family
nu a
circumstances,
întreprins
but the
să
commission
manifeste o abordare
did not
personalizată
take a
în cazul meu
personalized
și
approach
măcar
in
să
my
le
case
exclude
and did not exclude these
aceste cheltuieli,
expenses for the minor
mai ales că noi
children.
putem continua mai departe. De
Moreover,
exemplu,
I
pentru un
could
copil nou
continue.
născut nu
For
poate să
a
fie cheltuieli de
newborn, you
transport.
cannot have transportation expenses
El nu călătorește singur.
because minors don't travel alone.
Pentru un copil nou născut nu poate să
For a
existe cheltuieli
newborn,
pentru
you cannot have
telefonie.
expenses
Care tot
for a
sunt incluse.
mobile phone that
Și pentru
have
un
been
copil
also
minor,
included, and you cannot include for a
cheltuielile
minor
nu poate să fie percepute în mod normal cheltuieli pentru tutun sau alcool
expenses
și pentru
for
hoteluri și spa,
alcohol,
care sunt
hotels,
incluse în acest
tobacco,
calc,
spa,
care a fost folosit de
and
comisie.
but these expenses were included in the formula
Mai ales
used by
că
the Commission.
eu am precizat de mai multe
Moreover,
ori
I
și asta a fost
stated
apreciat și
several
a constatat
times,
la Curtea Supremă de
and it
Justiție
was taken into account
că
by the Supreme Court
în
of
această
Justice
perioadă
that during
eu
this
am trăit cu
time
părinții
I
fostului
lived
soț,
with
fostii
the
socri.
parents of my former husband, with my
Noi
former
trăiam pe
in-laws.
pământ,
We were living
având în vedere
in a
casa a fost
house,
plasată pe pământ.
not in an
A fost
apartment,
acolo o gradă în care
and we had a
legume,
garden where
așa mai
we
departe.
grew
Mai ales că
vegetables
3
and
copii din
fruits.
aceste 5
Moreover, 3 out of 5 children
au fost copii de la alt soț,
were children from a different
care cu
husband
haine, cu diferite, chiar și cu mâncare,
who helped with
care este
expenses
conservată, a
for
ajutat.
food and
Și asta în
clothes.
mod normal se întâmplă în țara noastră
And
în orice
this
familie.
normally happens in our country
Și
in
acest
any
lucru
family.
nicicum, aceste circunstanțe nicicum
And
nu au fost apreciate de comisie.
this circumstance was
această
not taken
lipsă
into
de
account
loialitate,
by the Commission. And this lack of loyalty,
lipsă de
this lack of
abordare personalizată,
targeted approach, personalized approach,
într-adevăr mă miră.
is surprising me.
Și se referă la nedepunerea declarației, eu vreau să vă
About
spun că
failure
Curtea
to
Supremă de
submit the
Justiție a
declaration,
constatat
I want to say that the
indubitabil
Supreme
și
Court of
irevocabil
Justice
că cazul meu
irrevocably found
este
that my case
asemănător
is
cu cazul
similar
altui candidat
to the case of another candidate
care a trecut cu succes
who
evaluarea,
passed successfully this
depunând două
evaluation,
declarații
failing
consecutiv.
to submit 2 consecutive declarations.
Și în cazul acestui candidat
And in the
a
case
fost
of
constatat
that candidate,
că voi
it
ați
was
avut abordare
found
diferită.
that you had a
Și
different
când noi avem
approach.
situație când
And when we
în
have
situații identice sunt două abordări diferite, este
2
discriminare.
different approaches in 2 identical situations,
Și eu
it
insist
equals to
că acest
discrimination.
comportament este
And I
discriminatoriu în privința
insist
mea.
that this behavior is discriminatory against
Eu
me.
în această perioadă nici nu am avut,
During this
nici nu
time,
am lucrat,
I
nici nu am fost
didn't
în
even
funcție,
work.
că sau
I
niște
was not
venituri
in that position
ilegale
in
din
order
punctul
to
de
have
vedere
some illegal income
care pot să provină din actele de corupere.
that could come out of corruption
Și asta nici nu a fost
actions.
constatat.
And it was
Și
not
dumneavoastră ați
taken into
verificat
account.
toate cheltuielile,
And
toate,
you
chiar ați
verified
avut și
all the
cardul meu
expenses.
bancar,
You
care
even had
ați putea
my
verifica
bank card,
ce
and
cumpăram
you
eu.
were able
Că asta
to
a fost pâine,
verify the
lapte,
data on what I was buying.
fructe,
Fruits,
sărdițele anumite și așa mai departe. Și dacă corupția în țara noastră se referă
bread,
la
milk, and so
aceste
on and so forth.
cheltuieli,
And if you refer to
nu
these
înțeleg de ce a fost
expenses,
privetingul inventat atunci.
I don't understand why preventing exists then if you don't count those expenses and you count others.
Asta e tot ce eu pot să comunic pe
This
această
is
întrebare.
all I wanted to say about this issue.
Okay, thank you very much, Mrs. Russo. I see that Nadezhda has raised her hand. Nadezhda, please take the floor. Yeah.
Vă mulțumesc, domn președinte.
Thank you, Mr.
Având în vedere că
Chairman.
este o audiere publică,
Taking into account that
aș
this
vrea
is a public
să
hearing,
fac câteva clarificări.
I'd like
Și
to
poate,
make
doamna Rusu, dacă
several
considerați
clarifications,
necesar,
and if
puteți
Madam
să
Rusu
interveniți din
deems
nou.
necessary, you
Dumneavoastră v-ați
can
referit la
intervene
modalitatea de
again.
calcul
You
a cheltuielilor de
refer
consum de
to
către
the
comisie.
calculation formula
Și îmi pare
for
rău că dumneavoastră utilizați informația
expenditures
care nu
used by
corespunde,
the
de fapt,
Commission, and I'm sorry that
adevărului și
you don't
realității.
use truthful
Comisia nu a călcat
information.
cheltuieli legate de
The
tutun și
Commission did
celelalte
not
care ați spus
add
dumneavoastră pentru
expenses
copii,
for
iar
tobacco and
modalitatea de
alcohol for
calcul
children. This
a
is a
cheltuielilor
formula of
care este
calculation
efectuată de Biroul
for
Național de
expenses that
Statistică.
has been developed
Și
by the
desigur că în
National Bureau of
fiecare caz în
Statistics.
parte,
And
atunci
obviously,
când
in every
persoana
case, every
vine cu
individual
probe
case, when a
că anumite
person
cheltuieli
brings
au fost
proof
mai mici sau mai mari,
about
asta se discută. La
bigger
dumneavoastră
or
a fost
smaller
cu totul
expenses,
altceva.
it is being discussed.
Dumneavoastră n-ați
In your
prezentat
case, it was
cheltuieli,
absolutely
n-ați
different.
prezentat
You did not
venitul
present
a
your
tuturor membrilor familiei.
the income
Dumneavoastră
of
ați
all the
prezentat
family
acel
members
venit
and
al familiei
your
dumneavoastră
expenses. You
abia
provided us
la
with the
Curtea Supremă
data.
de Justiție.
No, you
De aceea,
provided
cred că și
data
ar fi
on
corect și
the income of
și din
your
partea dumneavoastră
mother-in-law to the Supreme Court of Justice. So I think it would be good
și să
for
relatați
you
greșit cum au
to
loc toate
not
calculele, comunicarea putea să aibă loc,
communicate
foarte detaliată și comisia
wrongfully
la evaluarea
about
inițială
this
a
calculations. At the
utilizat
initial
toate datele de care
evaluation,
a dispus.
the
După
Commission
aceea
used
au fost
all the
obținute celelalte
available
date,
data.
desigur
After
că
we received
acest aspect a fost
other data,
clarificat
this aspect
și
has been
în
clarified.
notificarea pe care ați primit-o pe
And
11
in the
iunie, Comisia
SOV
clar
that you
v-a
received
scris
on
că
11th of
nu
June, the
mai
Commission
menține dubiile serioase
found
cu privire la
and
dezechilibrul de
mentioned
avere
clearly
din
that it
realizarea
has
dumneavoastră.
no
Doamna Nadejda, eu acum foarte atent am
doubts
ascultat doamna
about
Nona Țățorea, care
your
a spus
declaration.
că menține
Mr.
acest argument.
Nadezhda, I listened to
Și eu
Madam
mă
Totsorina,
miră
who
că
said that
dubiile care au fost prezentate în
she
scris
maintains this
a
doubt.
fost constatat că nu sunt dubii referitor la discrepanța între venituri și
In the
cheltuielile. Dar
written
acum doamna Nona Țățorea
declaration,
continuă să prezinte această
you said
învinuire,
that you
pot
had
spun,
no doubts, but
care de
Madam
fapt și
Totsorina
eu nu am
continues
văzut
with
în
this
dubiile serioase.
with this idea that there still are doubts.
I would suggest, Nona, that you maybe want to read out again the formulation of the serious doubts, as we have also communicated to you, Mrs. Rusu, during the serious doubts, in the serious doubts document. And then I would suggest, Nona, that you continue with your questions, but maybe good for the clarification also for the public that we know exactly what it is that the serious doubts are related to. So, Nona, please go ahead.
So let me read again. The Commission has serious doubts about the compliance of the candidate with the criterion of financial and ethical integrity with respect to failure to submit in 2017 a declaration of assets and personal interests for the period of 2014-2016 as required by the law. Because the National Integrity Commission had existed since 2013 and new legislation related to the declaration of assets and personal interests was adopted in 2016 that had been debated publicly since 2015, the candidate should have been aware of the basic rules on submission of declaration of assets and personal interests. This is the doubt we communicated to the candidate. We also expressly indicated in the statement of facts and serious doubts that the candidate mitigated doubts about her financial situation in 2014 and 16. So I think this was very clear in the statement of facts, and I think I made it clear now that we retain only one issue, which is related to failure to submit declaration, only one declaration covering the period of 2014 and 16, and all the issues related to financial situation of your family is mitigated. We just want for public knowledge to voice this, that you managed to mitigate that. So I think that it is right for the public to be informed that We did this exercise and you managed to mitigate that during written proceedings. This is just for public to be aware about this exercise. So I think that we clarified this matter. Unless you have any follow-up questions, I can proceed.
Eu mă bucur pentru această concretizare, că eu, sincer,
I
am
am
înțeles, așa cum am
glad
înțeles
for
din
this clarification
întrebarea
because
care a fost depusă acum în cadrul
as I
audierii,
understood from
dar
the question
atunci vreau să
asked
spun că
earlier in the hearing,
eu
but
nu
in this
înțeleg
case,
de ce
I would
atunci,
like to say
când
that
Curtea
I
Supremă de
don't
Justiție a
understand
constatat,
why
examinând
when the Supreme Court
cererile
found
mea de chemare privind anularea hotărârii privind
during
nepromovarea,
my
decizii privind nepromovarea,
appeal of
se a
the
constatat că
failure
pur și
decision,
simplu nedepunerea declarației
the
nu
court
poate
found that
constitui
mere
un dubiu
failure to file a
parte
declaration cannot
dacă nu sunt întrebări
amount
legate
to a
cu
doubt. If there
discrepanța
are
între veniturile
no
și cheltuielile și nu sunt
questions about
prejudiciu,
discrepancy between
atunci
income and
de ce
expenses,
Comisia a
and there is
schimbat
no
această abordare? Deoarece la prima decizie
damage. So
Comisia
why
scrie
did the
că
Commission change its
pur
approach?
și
Because in the first
simplu
decision, the
faptul că nu se
Commission
depuse
said that the
declarația
mere
nu
fact
este o
that
problemă, dar
a
din
declaration was
cauza
not
că
filed
prin
is not a
asta
problem, but
noi nu am putut să
because
verificăm
in that
cheltuielile
way we
și
could not check the income and
veniturile,
expenses,
dubiu a apărut.
the doubt
Fix aceeași situație noi
um,
avem și la
appeared,
alt
and
candidat
we
care tot
have a similar
are un simplu
situation
fapt de depunere
with another
declarației.
candidate who had one fact, no non-submission of
Cum
the
voi ați
declaration,
trecut
and
peste constatarea
how
Curții Supreme de Justiție care a
you stepped
constatat
over
că
the
pur și
finding
simplu
of the Supreme
simplu
Court of
fapt,
Justice that
nedepunerea declarației
held
nu
that
poate
mere
constitui un dubiu de
failure to file a
integritate
declaration
financiară.
is not a
Cum ați trecut? Cum
doubt
motivați
related to
asta?
financial integrity. How do you explain that?
Este o
How
constatare
did
care
you
este
step over it?
irrevocabilă, care este
This is a
obligatorie pentru
finding that is
comisie.
irrevocable and is binding for the Commission,
Și această constatare
because this
este
finding
asigurată prin articolul
is
120 din Constituția noastră.
guaranteed by Article
Este asigurată prin
120 of
articolul
our
6
Constitution.
din
It is
Convenția Europeană
guaranteed
pentru
by
Drepturile
Article
Omului.
6 of the European Convention on Human Rights.
Este un principiu unanim
This
recunoscut.
is a principle that is
puterea lucrului judicat.
unanimously recognized,
Este
the res
constatat.
judicata. It is
Cum ați trecut
a
prin asta?
determined thing. How did you just
De ce
step
ați schimbat
over it?
abordarea?
Why did you change the approach?
Thanks very much. I think this is, I would suggest that we go on with the questions that Nona may have in relation to this issue, in which also the question about the distinction between your case and other cases may also be touched upon. So I would suggest that we first go on with the questions and, of course, your answers, and we will take all your arguments into consideration when, of course, preparing our decision after this hearing. So Nona, please go ahead.
Thank you, Mr. Chairman. I have following questions to you, Mrs. Rusu. And my first question is the following. In your written submissions to the Commission and also during the hearing today, you considered that your failure to file a declaration while on maternity leave during the period of 2014-16 was similar to the circumstances of the candidate in the Commission's decision number 38 of 8 June 2003, and that candidate failed to submit declarations for the period of 2010-2011. Yet the Commission had reached opposite conclusions in those cases. Please explain why you consider that your situation is similar to the circumstances of other candidates mentioned by you.
Eu am avut această poziție și o mențin
I
această
had
poziție
this
în
position.
față
I
de Curtea Supremă de Justiție, față de
still
bugetul care
have the
examina
same
acest
position,
caz.
and
Și vreau să vă
before
spun
the
că eu
Supreme Court and
consider că
the panel that
noi
examined this
suntem,
case, but and I want to say that
suntem în situație similară,
we are comparative. We are in similar situations. We are both civil
în privința
servants
cărora a fost această obligație de a depune această
who
declarație.
had the obligation to file the declaration.
În ambele cazuri
In both
nu a fost
cases,
depusă declarația. În
the
ambele
declaration
cazuri
was not
asta
filed.
nu a fost
In both
intenționat
cases, that was
și
not
în
done
ambele
deliberately,
cazuri
and in
asta
both
nu a
cases,
fost sau nu a avut
that
scop
did not have the purpose to hide
venituri sau impozite
income
care trebuie să fie
or
evitate.
taxes that should have
Și în
been paid.
ambele cazuri,
And
noi
in
treceam
both
tot aceeași
cases,
procedură
we were
la
undergoing the
una
same
și aceeași
procedure
comisie.
carried out by one and the same
Și
commission.
această poziție a mea, așa a
And
fost explicată și la Curtea Supremă de
this was my
Justiție,
position. I explained it to the
care
Supreme Court,
a constatat că
and the
aceste două
court
cazuri
found
sunt similare.
that
Și
these
această
two cases
constatare,
are similar. And this finding,
dumneavoastră puteți nu fiți de acord cu
well,
dânsa,
you may
dar
disagree with
eu
it,
consider că sunteți
but
obligați
I
să o
believe
respectați.
that you are bound to
Că
respect
chiar
it,
și în legea
because
26
even
este
Law
expres
26
indicat că constatările Curții
states
Supreme de Justiție sunt
expressly that
obligatorii.
findings of the
Obligatorii.
Supreme Court
Probabil
are
că nu din
binding,
legea 26, dar din
or maybe not Law
din
26, but
decizia
from the
Curții Constituționale
decision
care
of a
examina
constitutional
această
court
chestiune.
that examined
Oricum,
this matter. Anyway,
constatările Curții Supreme
the
de Justiție
findings of the Supreme Court of
constatate
Justice
prin decizie irrevocabilă sunt obligatorii,
stated in the irrevocable decision
inclusiv și
are
pentru comisie.
binding for the Commission as well.
Iată de ce eu consider
That's why
că este tot aceeași
I believe
situație.
that the situation was the same.
Thank you for your answer. The second question. The Council of Europe's Group of States Against Corruption, this is GRECO, reports of 2006 and 2010 on Moldova concluded that there was no comprehensive system for declarations of interest and the existing system of declarations of assets was ineffective. GRECO recommended that the Republic of Moldova set up an efficient system for monitoring public officials' declarations of assets and interests. The National Integrity Commission was created in 2013. Public debate started beginning of December 2014 on new legislation on assets and personal interests. A new legislative package was adopted in 2016, reorganizing the National Integrity Commission as the National Integrity Authority. These developments preceded 2017, when you were due to submit your declaration for the period of suspension for 2014-2016. And I have following questions to you. In view of the above mentioned, please explain why you think that the entity that existed prior to the National Integrity Commission with responsibility for collecting declarations, and this was the Central Commission for Verifying Income and Property Declarations, was effective system of annual declarations of assets and personal interests.
Eu vreau să vă spun că chiar dacă
I want
presupunem
to tell you that
că
even
nu a fost
if
clar
we assume
atunci
that it
când
wasn't clear
comparatorul meu, da,
when
acest alt candidat care a trecut
this
pre-vetting
other
cu
candidate that I compare myself to, who
problemă
passed
similară, pentru
the
dânsa nu a fost
pre-vetting
clar.
with a similar issue, it
Eu
wasn't
vreau
clear
să
for her.
ținem minte că
So I want
dacă
us to
comisia are așa
remember that
abordarea, un
if the
funcționar public
Commission has such an
poate să aibă
approach that
dubii,
a public official may have
la lucru, având
doubts
posibilitatea să
being
aibă
on
acces
the
la
job,
toată
having the
legislația,
possibility to access all
discutând
the
și cu colegi care
legislation,
depun
talking to
acești
colleagues
declarații
that are
și dacă
filing
nu
the
mă
same
greșesc, nu a fost
declaration.
stabilit
And
că
if I'm not
încă
mistaken,
cineva
it
din
was not
procurorii
found
care au
that
trecut
one
evaluarea
more of the
tot au
prosecutors
avut
that
dubii
passed the
despre cum să
evaluation
depună
had
declarația.
doubts as well about
Sau
how
trebuie să fie
to
depusă
file
sau
the
nu trebuie să
declarations,
fie depusă.
or
A fost
should
constatat
they
numai în privința
file or
acestui
not.
candidat.
It was found only with
Și
respect to
presupunem că
this
normal,
candidate. And again,
omul poate să
uh,
nu înțelege
we can
până la
presume
urma
that
urmei cum
it's
este
possible
corect.
for a person not to
De ce în
understand how
cazul
to do it
meu,
right.
când eu am stat în concediu
So
de îngrijire
why
a
in my
copilului,
case, when I was on childcare leave,
nu am discutat cu colegii, nu am
I was not talking to
avut
colleagues.
posibilitatea să
I did
fiu
not
pe
have a
fir
possibility
permanent, având copii.
to be in touch always because
Și
I had
evident
children.
că am fost un alt
And
proces.
of course, it was a different
Ieșind
process.
din concediu de îngrijire a
When
copilului,
I
că eu
finished my childcare leave,
nu am înțeles
I,
corect cum trebuie să fie
in
depus
fact,
și
that
am
I did
depus
not
în anul
understand
2018
correctly
în
the
anul
way it should be done,
2017.
and I filed in 2018 for the year 2017.
Omițând să indic Și anul
and
2016
it
și
was
din momentul când am ieșit
I omitted
din anul
to
2014.
mention year 2016 and generally starting
De
with
ce în
year
cazul
2014
meu
when childcare
asta este
leave
mai
started.
grav?
Why in my case
Dacă
this is
noi
more
vorbim despre
severe?
situația când asta
While we
este
talk
făcut
about the situation
neintenționat,
when this was
nu este
done
intenția.
unintentionally, there was no intent behind it.
De ce în cazul meu
Why
este mai
in
grav?
my case
Cu ce eu sunt
this
de
is
vină
worse?
comparativ
How
cu
am
candidatul
I more
care tot a
to be
fost,
blamed
de
compared to
fapt,
the candidate who
în
was
situația în care
also
toți procurorii au
actually in a
înțeles corect,
situation where all prosecutors understood correctly?
ori nu există informație că cineva,
Because,
uh,
well, there's no information
dumneavoastră
that
ați constatat, nu
someone,
numai un
or you
procuror,
checked, it wasn't only
încă
one
cineva nu a
prosecutor,
depus
but
declarație.
one more person did not file
Și
the
când tu ești
declaration.
la lucru, când
And
se
when
depun
you are at
declarația,
work, when it's the period of
colegii
filing
discută unul cu
declarations,
altul, a depus, nu a
colleagues are
depus, când
talking
a
to
depus
each
și așa
other,
mai
you know,
departe.
who filed, when filed, and how it works, and
Este
so
încă un
on.
moment. Ieșind de
There
la
is one
lucru,
more aspect. When
eu
you
nu depuneam declarația cu
when I
cred
left work,
colectivul,
I
toți
was not
judecătorii
filing the
care am
declaration
lucrat
with
și
the
toți
entire team, with all
lucrătorii.
judges with whom I work, with the entire staff where I work.
Și evident că asta tot influența,
And of course, this
că eu nu
also
am depus-o,
influenced
anume
the
pentru
fact that I did not
toată
submit it
perioada.
for the entire period.
Eu insist că
I
chiar
insist
dacă nu a fost
that
clar,
even though it was
cum
not
a
clear,
constatat Greco,
as Greco found,
modalitatea cum trebuie să fie
the
declarație,
way a declaration
veniturile
should
și
be,
cheltuielile sau
how
situația
income and
financiară,
expenses
pur și simplu faptul
should be
că
declared.
declarația
But
trebuie să
still, the
fie
mere
depusă,
fact that a declaration must be
mi se pare
filed
că este un lucru clar.
is a clear thing, I think.
Doamna în cauză nu a trăit
That lady
într-o ouă
did
care
not
nu pervenea nicio informație.
live in a bubble
Colegii
where she received no
au depus
information.
declarații
Her colleagues were filing declarations,
și 2 ani consecutiv
and 2 years in a row,
a fost menținută această poziție că nu trebuie să fie depusă declarația.
she had the same
Da,
position that
eu
she did
înțeleg
not
că
have to file
această
the declaration.
poziție a fost
I understand that
neintenționată,
this position was not
dar și în cazul
intentional,
meu, ea nu a avut
but in
nicio
my
intenție și asta a fost
case, it was the
constatat.
same. No
Nicio
intention
intenție
behind it. This was found.
de a
No
ascunde
intent.
ceva
No intent to hide
sau de a
anything,
prejudicia statul sau
or
de
to
a
damage the
produce
state,
niște
or
efecte
to
personale pentru
generate
mine
some personal
sau pentru
effects for
familia mea
myself or
favorabile.
for my family. So to generate some positive
Eu
effect.
mențin poziția mea că sunt cazuri similare.
I
Ba mai mult de
still
atât,
support my position.
Curtea
These are
Supremă de
similar
Justiție a
cases.
constatat
Moreover,
că
the Supreme
cazul
Court of
meu,
Justice held that
comparativ cu cazul
my case,
despre care
compared
noi
to
discutăm,
the case that we are discussing now,
cazul doamnei procurori a fost și încă mai
the
complicat.
case of that lady
Încă
prosecutor
mai
was even more
complicat din punctul de
complicated.
vedere că ea se
It was
afla la
more
lucru.
complicated because she was on the job.
Asta este răspunsul meu.
This is my answer.
Okay, it's accepted. And the second question is as follows. Please also explain why you consider that the timing of the establishment of the National Integrity Commission in 2013 is irrelevant for your evaluation, and that the commission should not differentiate you and the other candidate that you referred on that ground.
Deoarece eu consider că aici
Because
sunt
I believe
importante
that
două circumstanțe.
two circumstances are important here. The
Declarația
first
nu a
one,
fost depusă,
that the declaration was not
având
filed,
această obligație.
while the
Și a doua
obligation to do so
circumstanță,
existed. The second
că
circumstance
nu a fost constatată nicio
is that
intenție.
no
ambele
intent
cazuri.
was found in both
Eu
cases.
insist, sunt
I
cazuri
insist
similare.
these
Eu
are
insist că noi
similar
suntem
cases.
două
I insist
persoane aflate în
we are
situații
two
similare
people in
și
similar
eu
situations.
declar
And
că eu
I
văd în
declare
această
that I see
încercarea de a afla de ce eu consider că
this
este cazul similar,
this attempt of
mai
trying
ales în
to
cazul când la Curtea Supremă de Justiție
asking me
Europeană
to
și
explain
deciziile
why
astea,
I think
face
it's
reprezentantul
similar,
Comisiei
because
și
it's similar,
cunoaște poziția
because
mea.
in all Supreme Court
Iată,
hearings,
eu
the
simt
representative
că
of the
în
Commission
așa
was present, and
circunstanțe,
they
această
know
abordare
what my
pare unei
position was. So in
discriminatorie,
these circumstances,
deoarece când noi avem situații
such an
similare,
approach
dar o abordare
seems
diferită,
discriminating,
fără
because
o
when we have
justificare,
similar situation but
nu eu
different
trebuie
approach
să
without
depun
justification,
efort să vă explic de ce
it's not
consider că sunt
me
similare. Curtea
needing
Supremă de
to
Justiție a
make effort to
constatat acest
explain you
lucru.
why cases are similar, because the court,
A
the Supreme
sugerat
Court,
Comisia
held that.
consideră
And
să
it's
explice
the opposite.
mie
Is
și
the
publicului de ce
Commission
considerați că
wants to
ele sunt
explain to
diferiți.
me and to the public why you
După
believe
cum
these cases
Curtea
are
Supremă de
different.
Justiție a constatat invers
The Supreme Court
că ele sunt
held
similare.
the opposite,
Asta
that
e relevant.
these
De ce
cases
voi
are similar.
considerați că ele
That
sunt
is
diferite?
relevant. Why do you believe that these are different cases?
Thank you. I'm done with my questions unless other commission members have any other questions. Thank you.
Any questions on this issue from the other members? Yes, Nadezhda.
I would like to continue the second issue and just make a clarification before that. Is that okay?
Yeah, please go ahead. Yeah, yes, sir.
Mersi. Doamna Rusu, iarăși doar o precizare
Ms.
pentru
Rusu,
clarificare în
one
cazul că iarăși poate vreo
clarification
neînțelegere.
in case
Atunci
if
când vorbim
it's
despre
some
obligația
misunderstanding.
de
When we
depunere a
talk about the
declarației
obligation to
pentru
file
perioada
a
suspendării
declaration for the
contractului,
period
acea
while your
declarație
contract was
acea
suspended,
obligație
that
survine
obligation
din ziua
happens
returnării deja la
starting
birou
on
și
the day when you are
declarația
back
trebuie
in
depusă
office,
de
and
timp
the
de 30 de
declaration
zile.
is
Deci
supposed to be
comisia
filed within
niciodată
30
nu va
days. So the
imputa
Commission never
ceva
imputed
că nu ați făcut
you
cât
that
erați acasă
you
cu copiii
did not do
dumneavoastră.
something
Este
while you were
vorba doar
staying at
de
home with your
perioada când
children.
deja
It's
dumneavoastră vă
about the
aflați
time when
la
you
servici
were
zilnic
back
alături de
at work
ceilalți
every
judecători,
day
da? Pentru
with the other
claritate.
judges.
Acum
That's for
vom
clarity
trece la
purposes.
problema a doua.
And now we'll move
Și
to the
iată
second issue.
concretizez. Doamna
I
Nadejda,
want
fix
to
așa și
clarify
eu
another
am
thing. Miss
explicat
Nadezhda,
că eu
I
când
explained that in the
ieșeam
same
de la
way
lucru,
when I was
când am ieșit, eu nu depun
when I
declarația cu toți
came to work,
colegii.
I was not filing the declaration with all
Declarațiile
colleagues.
se depun individual de mult timp
The
și de atunci.
declarations
Iată, vă
are
spun că
being filed
probabil că
individually for a long
dumneavoastră
time
nu
now.
cunoașteți cum
No,
asta se
you
face în
probably
instanțele
don't
de
know how
judecată
this is
sau
done in courts,
sunt
or
convinsă și în procuratură fix
I'm
așa
sure
e
that
situația.
in the
Noi
prosecution
permanent
service the
întrebăm
situation is
unul
the
pe
same.
altul. Ai
We
depus
always
declarația, ai
ask each
depus,
other,
cum
did
ai
you
ridicat
file your
acta? Și noi
declaration? How
spunem,
did you
iată,
write
eu
that?
știu cum se
And
face
we talk.
acum
I
și
know
aceasta,
how it is done now.
fix acest lucru a fost
And
și anterior.
the same thing
Pur și
was
simplu situația mea a
before.
fost
It's
una
just my
neobișnuită.
situation was
Am
unusual.
înțeles. Haideți să
I
trecem la
understood you.
a doua
Let's
întrebare
move
și
to the
aceea ține
second
de
issue, and
întârzierile
that
legate de
is
examinarea
about
celor 16
delays
plângeri cu
in
privire la condițiile de
examining the
detenție.
16 complaints on
Dumneavoastră ați
detention
primit notificarea cu
circumstances. You
privire la
received the
dubiile
statement
serioase
of facts
ale comisiei. Eu
regarding
am să dau
the
citire
serious
doar
doubts of the Commission. I will
dubiului,
only
și anume comisia are
read
dubii
the doubt,
serioase cu privire la
namely that the
conformitatea
Commission has
candidatei
serious
cu
doubts
criteriul
about
de
candidates'
integritate
compliance with
etică,
the
conform
ethical integrity
articolului 8,
criteria
alineatul 2,
um,
litera A din legea
according to
26,
Article 8, paragraph 2,
din
letter A
2022,
of Law
în ceea
26 of
ce
2022,
privește întârzierile
with
la
respect
examinarea a 16
to
plângeri privind condițiile de
delays in
detenție
examination of
în
16
anul 2019.
complaints on
Dubii
detention
care nu
conditions
au
in
fost
2019,
atenuate de către
which have
candidată.
not been
Dubiile
mitigated by the
comisiei
candidate.
sunt accentuate de
The
faptul
Commission's
că
doubts
argumentele
are
candidatei
heightened
privind
by
cele
the fact that the
56 de
candidate's
dosare
arguments
pendinte
regarding the
la
56
judecătoria și
pending
cele
cases
200 de
with
plângeri
Criuleni
similare
Court
cu
and the
cele
200
16 plângeri examinate
complaints
la
that were
judecătoria
similar to the
Cahul,
16 complaints
sediul
examined
Taraclia,
at
nu au
Cahul
fost
Court Taraclia
confirmate de
Office
informațiile
have not
colectate
been
în
confirmed
cadrul
by
evaluării
information
reluate de către
collected
comisie.
during the resumed
Comisia, de
evaluation.
asemenea, are preocupări
The
serioase cu
Commission has
privire
also
la
serious
faptul că
concerns that
candidata nu a examinat cele
the
16
candidate
plângeri depuse în baza
failed
legislației
to examine the 16
menite să ofere un
complaints
nou remediu pentru
filed
plângerile privind condițiile de
according to the
detenție.
legislation aimed
O
at
problemă
providing a new
sistemică
remedy for
invocată de
complaints
reclamanți în fața Curții
against
Europene pentru
detention
Drepturile
conditions,
Omului
which was a
și
systemic
cu privire
issue
la care au
raised
fost
by
identificate
applicants
încălcări
before the
de
ECHR,
către Curtea Europeană
and
pe care
regarding which
autoritățile naționale erau
the
obligate
ECHR
să le
found
abordeze, iar
violations, and
instanțele să
national
le
authorities were obliged to
implementeze.
address them, and for courts to implement them. And according to procedure, you have 15 minutes when you can provide any explanation deemed necessary, besides what was provided in writing already that the Commission received and analyzed. Thank you, and the floor is yours. In the answer that I provided to the Commission, I mentioned that the 56 cases were part of my procedure. I don't understand why the Commission couldn't find them, but they were left in my procedure not by a verbal order. They were, so it was a Supreme Court decision that decided that when I needed to go back to Cahul Court Taraclia Office to continue working, and this is very easy to check. I don't understand why the Commission did not find them. When it comes to my statement about the approximately 200 cases examined by me, I want to clarify, and I actually specified that in the answers. I did not say in the Supreme Court that there were 200 similar cases. I said generally 200 cases. I examined 200 cases during that period of time. And in the answer, I provided you more accurate, more concrete information. There were 215 cases. These are decisions that are easy to check. And I want to tell you that, say we talk about a complaint compared to a criminal case or a civil case, and I examined and I including those 215 cases, included criminal and civil cases that I examined. Every judge and prosecutor and attorney and every lawyer understands that a civil and criminal case requires more effort sometimes. It requires more time, more hearings, more work. And when I talk about approximately 200 cases examined by me, I did not mean 200 complaints. I was talking about all cases that I examined during that period of time. And if you analyze it, I provided a calculation where I explained why, in the situation in which I was at that time, when I had to travel for almost 4 hours every day to get to work and then back home with public transportation, changing that, having cases in two courts. And this was mentioned in the Supreme Court, and it's written in the decision. And I insist that these circumstances are taken into account. When you look at my performance, if I could, in the same situation, to examine cases or to work, would I be able to work more efficiently with all those number of cases? And again, making reference to the way you checked all the cases and hearings that I held, that means that you saw that every day I had many hearings every day from 8 to 10. It was multiple meetings. It was very seldom that it was difficult. And it's a person who's physically exhausted after spending 4 hours in public transportation. But I also found two more circumstances, and the Supreme Court spoke about that in its decision, and I submitted the materials of medical investigations that I had at home about my health condition at that time. And I want to tell you that, yes, I understand. Sometimes we want a judge to work more efficiently. But we should not neglect or to put aside or to turn a blind eye to the situation when you are afraid that your disease is incurable and you have 5 children and it may happen so that they are left without a mother soon, any day, but you hold yourself together and you go to work, you travel by public transportation. Back using like occasional transport, and it wasn't for one day only. I just don't want to say that this is an effort that every citizen of this country should giving me praise for that. No, but for the very least, I ask for this to be taken into account when you look into my performance, especially since my performance and effectiveness of me was I able to examine cases faster, better, or more cases, that was analyzed, and that is the object of examination. It was part of a disciplinary proceeding where the disciplinary board found that the judge was not guilty of delays in the examination of those complaints. The situations were different, but it wasn't the judge to be blamed. And then it was found again during the judicial review. And the Court of Appeal mentioned the same circumstances, mentioned the personal circumstances in my life at that time. I mentioned the same things in the Supreme Court, and the Supreme Court analyzed these aspects and found that the situation was, in that situation, there were personal circumstances that should have been considered by the Commission, and I'm so sorry that I faced such an inhuman approach, lacking empathy altogether. You didn't even mention one word in what circumstances I was working. This is very sad. This is very sad that sometimes in cases when you have a candidate who, for instance, increased doubled the amount in the sales contract for the bank, you mentioned that he wanted to help another family. What a noble and beautiful explanation you found. Why you couldn't find one for me, at least half of such an explanation? I'm not asking you to feel pity for me, but I'm asking for a more personalized approach, an approach that would reflect the circumstances that you are examining.
Mulțumesc, doamna Rusu. Mai vreți
Thank you,
ceva
Ms.
sau
Rusu.
putem
Would you like to add anything, or can we try to get some clarification? I want to add one more thing. This matter about disciplinary proceedings was examined by the Supreme Court as part of a judicial review. There was a competent court, and the object of that examination was my performance coefficient, like am I guilty or to be blamed for that or not? Was I to be blamed for that? And I received the decision whereby the competent court established irrevocably that the judge was not guilty in that case. In this situation, I demand that my right is ensured, that once a case was examined, once there is a decision that had or looked into the same object, my performance coefficient, it should be obeyed. I shouldn't have now or 10 years later, 5 years later. This is way beyond the statute of limitations. I shouldn't have to explain myself every time how I was traveling to work, what diseases I had, and so on. How many cases I examined, how many hearings I held. I also want to enjoy, like every citizen of this country and of the European Union, I want to
Eu vreau să mă oferiți
enjoy, to benefit of the power of res judicata. I should be able to enjoy that.
numai că există hotărâre revocabilă și întrebarea să fie închisă.
Because it should have been enough that I stated that there was an irrevocable decision and it should be closed. Thank you, Ms. Rusu. I would like to mention that the Commission is not a disciplinary body. We are not looking into your disciplinary violations. You look into my performance. We analyze the candidate's compliance, your compliance in this case, with financial and ethical integrity criteria as provided for by Law 26. Now, Ms. Nadezhda, look, then, if it is found that I did everything possible to examine those complaints, but it didn't happen, then how can you get an ethics doubt? This is how you interpret, Ms. Russo. No, I'm not interpreting. Let's move to the another issue. This is res judicata. If I may, the Commission expresses its opinion in its decisions. We are not having this discussion. I am very much looking forward to get your decision. So you received the first decision and you will receive a decision after this as well, of course. Let's move to the questions because that's the purpose of a hearing, namely
in the examination of the SCJ of your appeal, the Supreme Court of Justice, the special panel, found out that the Commission did not consider how many similar cases, and this is from the decision of the Supreme Court of Justice, how many similar complaints the candidate actually managed to examine during the reference period. The Supreme Court of Justice decision states that you had this argument that you examined in due time 200 cases. The special panel had no information about these cases, nor did the Commission's representative, because the information was presented there on the spot, so the Commission was not able to collect new information. During the resumed evaluation, the Commission requested information at the Cahul Court, Taraclia Office, and according to this information, in the period between January and November 2019, you were assigned 450 cases, including 6 civil cases, 1 criminal case, 1 contravention case, and the rest, there were two categories. Half of them were requests from prosecutors and 241 complaints involving conditions of detention. You received all this data in the statement. Out of these 241 complaints, in this period of time, you examined 55 within 3 and 6 months. No, actually within 4 and 6 months. And 186 cases you were not able to finalize. They were finalized by other judges. You did not finalize those cases. Coming back to the same question included in the statement. So the Commission was not able to identify the 200 similar complaints that were examined and finalized by you within this deadline. Let's say not 3 months, but 6 months. Now, can you explain this a little bit more, because I understood partially from your intervention. As I explained in my answer to the statement on facts and serious doubts, I'd like to clarify that Perhaps the panel of judges or the Supreme Court of Judges did not understand correctly. I referred to approximately 200 cases that were examined. 200 examined cases, not the same cases, not cases of certain categories. 200 in total. And when I received your statement of facts, I checked the number and it was actually 215. I was not referring to specific cases. And obviously you cannot lie about a situation that can be verified very easily. When I said approximately 200, I did not remember the exact number and I estimated the figure. But I referred to the issued decisions, to the cases in general. Okay, let's stop here and let's clarify things. In your written answer, you said that you examined 49 cases in 2019 in Criuleni Court and 166 cases in Cahul Court. So these 215, this is the result of the cases at two different courts. Yes, these are two different courts, but I examined them. Okay, let's take January-November 2019, 166 cases in Cahul Court. Is it right? I don't have the correct. I don't have the answer in front of me, but you have my answer. According to the data that we received, 55 refer to conditions of detention, and you finalized them. Civil cases were 6 or 7. Okay, let's say you finalized them, and it means that the others were some requests from the prosecutors. In a judge's job, there are more complex cases with over 100 pages, and they can be examined over years and years. But we have other cases that are examined quicker, but it doesn't mean it doesn't require effort, concentration, and time. Perhaps it's about those cases. From the data that I had and that I presented in front of the Court of Appeal, so this is the data that I used also in the judicial control, and I presented you the same data. Okay, let's finish with Taraclia Court, and then we'll go on and talk about Criuleni Court. According to CHA decision from 29 January, the panel concluded that the Commission was not able to prove how many people were freed from detention out of those 16 complaints. During the evaluation, the resumed evaluation, the Commission collected this information and identified 2 people who were freed. But you mentioned in front of before the SCJ that no one from those convicted out of 16 cases were not set free. Please explain, why did you declare because before the SCJ that none of the complainants were set free? And are you against the fact or are you denying the fact that 2 were set free? The cases are not examined by me now, so I cannot say much about this, but taking into account the fact that the disciplinary procedure took place. You said the cases were examined in January 2020. So the disciplinary procedure took place until October 2020. On 6th of October, the Superior Council of Magistracy issued the decision. And after that, there was judicial control, and the same issue has been examined. And from all the information in the case about these complaints, I did not see this information. And when I talked before the Supreme Court of Justice, I referred to the fact, and it to the fact that this was my deduction, or this was my understanding of the facts, because I did not know how the cases were finalized. And this was not presented in your statement. So this was the information that I knew about at that time. After that, you provided me with other information, and I see that there's a difference. But everything that I said before the Supreme Court of Justice was from the knowledge that I had. There was a judicial review, disciplinary procedure on this, and I was sure that the information in those documents, within those processes, was complete. Thank you very much, Madam Rusu. Articles 473 and 473 2 and 4 of the Criminal Procedure Code, in force since 1st of January 2019, introduced a new mechanism for examining complaints concerning detention conditions that seriously affect the rights of the convicted or detained. This mechanism was introduced to respond to the systemic problems identified by the European Court of Human Rights related to inadequate conditions of detention in the Republic of Moldova. And we have the case Shishanov versus the Republic of Moldova. Several questions here. In 2019, when such complaints were coming to you, were you aware that it was about a new mechanism introduced by the state in order to improve the situation in terms of detention conditions? Yes, of course I knew about it. Moreover, back then, when this issue has been discussed, whether I agreed to receive such complaints, to examine them as an investigative judge, I told them, no, I did not agree to work as an investigative judge, because I had cases in 2 different courts already. And I submitted a request to be transferred, and I do this every time a competition is announced. It would be more efficient for these complaints to be distributed to other judges who are in one court, who are not going back and forth to different courts, and who do not intend to transfer to another court. After that, I was diagnosed. For your protection, you cannot. If you want to, you can restrain from telling about this. I regret that I did not put it in writing, because if I did, it would be more efficient. But taking into account all the circumstances I was in, I tried to do my best. I worked with prisons since 2012. I worked actually with a closed type prison, and I examined a lot of aspects related to detention conditions. And I was not indifferent to this cause. And even though I did not examine the cases in due time, it was the result of several circumstances. I'm a human being, and I was not able to eliminate those circumstances because it was not because of me, it was not my fault. And at the Superior Council of Magistracy, when they attributed me the mandate to examine cases as an investigative judge. I called them and I told them I did not agree. And in the end, I was designated this mandate, even though I did not agree. And even though everything I say now seems like a set of many circumstances, all the colleagues knew about them, and the SCM knew about this. Madam Rusu, these changes introduced a new mechanism requiring judges to examine these complaints within 3 months. In 2020, according to information from the government and confirmed by NGOs, the Council of Europe, while monitoring the way of implementation, the implementation of this decision, it was found that even though the law provided for a deadline of 3 months, in the majority of the cases, judges were not able, were not managing to examine these cases in 3 months. So such complaints were being examined within 4-6 months, and we referred to these reports in the documents sent to you. So how can you explain that out of 241 complaints within 6 months, you were able to examine only 55? Thank you. Madam Nadezhda, I will not explain again all of my circumstances. I already did that. These circumstances were examined during the disciplinary procedure and during the judicial review, and there has been an irrevocable decision issued that found a fact and I think that it's not worth it to repeat over and over the same information. You also
notificare și doar ca să precizăm, din cazurile pe care le-am, 16 cauze pe care le-a examinat comisia,
these cases,
într-o cauză de 2 ori și în altele
so
4
in
cauze,
5 cases, and one case was twice, you have postponed hearings for the reason that the prison administration did not provide the reports on the conditions of detentions. According to the law, such report was not mandatory for the examination of such cases. Could you explain why you postponed these hearings and you insisted on receiving that report from the penitentiary institution? Perhaps this question derives from the lack of knowledge on your side in terms of certain peculiarities. When you receive a complaint, it's very simple, and it's written by the convicted, by the detained, and
modificat termenul de ispășire pedepsei sau în care
they
circumstanțe el
cannot,
a fost
they
destitutit
do not
el a
refer
fost,
to
probabil a fost, de exemplu, mutat dintr-o
certain
funcție chiar în
aspects
altă
that
funcție
should
chiar
also
în
be
diferite
mentioned.
condiții. Da?
For instance, the
Iată,
fact
în
that they
acest
were
raport
transferred from one
se deținea
detention center
și
to another. In this
judecătorii d'instrucție
report,
solicitau de la penitenciar să
more
prezinte
information
acest
is
raport
provided, and
în care se deținea toată
investigative
informația.
judges
Dacă el a
need
fost
these
transferat
reports
în
with
diferite
all this
penitenciare pe
information
această perioadă,
about
dacă pe
transfers
această
during this
perioadă
period
el a
of
fost
time,
deținut, în ce celulă a fost
in
deținut,
what types
deoarece
of
celulele
cells
penitenciar sunt diferite.
this
Într-o
person
celulă
was
poate să fie
detained,
așa
because
condiții, în altă celulă poate
different
să fie diferite
cells
condiții.
have
Pentru
different
mine a fost
conditions
important că în
of
raport
detention.
l-am
So for
indicat,
me,
în
it is
raport să fie
important,
indicat
and
în
I
câte metri pătrați a fost această celulă, câte
requested to
persoane au fost
know
deținute potrivit
the
aceeași petiționar.
area of the cell,
Ca
the
pot să înțeleg
number of square meters of
când
the
emit
cell.
decizia,
And
să
in that
trebuie,
report,
el
you can
trebuie să
receive
fie
all this
publicat
information.
o zi, două
When
sau trei
you
zile
issue
pentru
a
a micșora
decision,
această pedeapsă care el ispășește. Și
Am
dacă, de
înțeles.
exemplu, eu constatau
so
prin acest raport că
if I'd
pot
found
ținut 7 persoane pe
that
4 metri pătrați,
there were
această
7
celulă,
people
evident că
detained
asta
in a
a fi
cell
fost,
of
a fost ușor de
7
indica
square
în
meters, then yes,
închinierea mea că situația sau
it would be
condițiile au
helpful
fost
for
inumane
me
și
to
degradante pentru
state
deținut.
in my decision that the
Mai
conditions of
ales că
detention were
mulți din deținuții în
inhumane
penitenciarul numărul 1,
and
condițiile ca și prin
degrading.
rapoartele care au fost publicate pe această perioadă,
And
în penitenciarul numărul 1,
in
condițiile au fost încă mai bune.
penitentiary,
Dar, de exemplu, penitenciarul numărul
in detention
13
center number
au fost
1, the conditions
extrem
are
de
horrible according to reports,
grele.
and
Și pentru
we also
mine a
have
fost
prison
foarte
number
important
13.
acest raport să fie.
So
Deoarece
this is
din
why
această
I
informație
need
eu
these
deduc în
reports.
ce condiții el a fost deținut.
From the
Deoarece
information in the
deținutul
reports,
nu
I
poate
can
să țină minte
understand the entire situation, because
circumstanțele, mai ales că
the
acest raport este
detainees
important
cannot
să
provide
înțeleg
all
ce
of this
perioadă el deja
information,
a
and
ispășit.
it helps me to understand what is the
Micșora
time that
pedeapsa.
they
Asta poate să se
already
poate cu o zi, fiecare
stand
zi
in the
este
prison.
important. Asta
Am înțeles,
este
e
un
clar.
lucru foarte,
Okay,
foarte
I
concret,
understand.
mai ales că în
And the
penitenciarul
reports
numărul 1
present this information in a
au
complete
fost
manner.
deținuți persoane care au avut de ispășit pedeapsă cu 18 ani, 17
For
ani.
instance,
Asta e o perioadă foarte, foarte lungă.
there are
Dumneavoastră
people
sunteți la
spending
curent dacă acest
or
număr
having
de
a sentence of
pedepse a
17,
fost
18
discutat
years.
între judecători sau la, nu știu,
Did
sau la cursuri
Were you
speciale,
aware
a fost
about
parte
this
din
new remedy?
discuții cu
Did you
privire la,
participate in
nu știu,
discussions with
probleme
other
pe care
judges
sunt
about this? Did you
sau
discuss
de
about
fapt
the
au fost lăsați
existing
nepregătați
issues,
în
or
urmare
were you left to
instrucțiuni
just
și
implement
sfaturi?
this new
Eu vreau să
provision
vă spun
without
că
any guidance?
probabil peste 2 sau 3
I
luni,
can
nu
tell
știu
you
să
that
minte așa precis,
after 2 or
au
3
fost
months, I don't
făcută
remember,
o conferință foarte mare în care au fost invitate toți
there
judecătorii
was a
de
conference, a big
instrucție,
conference organized
cu
for all the
reprezentantul,
investigative
cu
judges.
avocatul poporului și
There was
reprezentantul CEDO de la
the
CEDO, care a explicat
ombudsperson office,
unele
the
chestiuni și a
ombudsperson of
fost
Moldova,
foarte, foarte
and
multe probleme care
a
atunci au fost
representative of
detestate pe urmă deja
ECHR in
examinării.
Moldova.
Și puteți chiar verifica și este un
And
lucru foarte
you
cunoscut că
can
foarte mulți
verify,
clienți
and
judecătorilor
it
de
is
instrucție
well
care au fost
known,
trimiteri
very
referitor
many
la admiterea
decisions
plângerilor au fost anulate
on
spre cursele de apel.
accepting the
Judecătorii
complaint
aflau în
were
situația în care nu
appealed
pot să
and were
nu au fost
annulled by
previzibili
the
cum
courts of
corect poate să
appeals
fie aplicat.
of
Dar
appeal.
necătând la acest
So
fapt,
sometimes judges
vreau
don't
să
know
vă
how
spun
to
fără un raport detaliat de
correctly
la penitenciar,
implement
care este
these
organ care
provisions. So
urmărește fiecare
without
zi
a report
și fiecare
from the
deplasările
prison, from the
condamnatului, este
penitentiary
imposibil să
institution,
examinezi.
it is impossible to examine
Mersi.
such
Doamna Rusu,
complaints.
trecem
Thank
la
you. Madam Rusu,
ultima
we'll
întrebare
move
din
on to the last
acest
question.
capitol de la această problemă și anume asta ține de
in this
activitatea noastră
chapter,
deja la
and
Curtea
it is
la
about
judecătoria
your
Criuleni,
work
sediul dosare.
at
Doamna Rusu, în comunicarea scris cu Comisia în timpul evaluării
In
inițiale,
the
dumneavoastră ați
written communication with the Commission
menționat
during the initial
că
evaluation, you
aveați
mentioned that
56 de cauze
you had
pendinte
56
în
pending cases
examinare la judecătoria Criuleni
in Criuleni Court.
și între noiembrie
And
2018 și
between
ianuarie
November 2018 and
2019,
January
dumneavoastră
2019,
v-au fost repartizate cazuri
you
de
were assigned
drept comun, civile, penale și
common law
civile,
cases, criminal
care
and civil
deseori
cases,
necesită destul de mult timp pentru a
which
fi examinate.
often require longer time
Dumneavoastră ați menționat acest
for
argument
examination.
și în fața
You
Curții
mentioned
Supreme de
this
Justiție.
argument before the
În
Supreme Court
timpul
as well.
evaluării reluate, Comisia a solicitat
During the
informații
resumed
de la
evaluation, the
judecătoria
Commission
Criuleni.
requested information
Conform unei scrisori,
from Criuleni
scrisorii de
Court,
la
and
judecătoria
according to a
Criuleni, care
letter
dumneavoastră ați
from
primit-o împreună
Criuleni
cu
Court
materialele
that you
evaluării,
also received with
dumneavoastră
the
nu ați activat
evaluation
la judecătoria
materials,
Criuleni
you
între
did not
ianuarie
work at
și
Criuleni Court
noiembrie
between
2019
January and November 2019
și deoarece delegarea noastră la
because
această instanță, transferul
your
temporal,
delegation to that
a
court, the
încetat
temporary
la
transfer,
16 octombrie 2018.
ended on 16th of October 2018.
Scrisoarea la fel menționează că după acea
That
dată
letter
dumneavoastră nu
also stated
ați
that after that
nu v-au mai fost
date,
repartizate
you
cauze
were
noi.
not assigned any new cases.
În același timp, dumneavoastră aveați o listă
At the
de
same
cauze
time,
pendinte și,
you
într-adevăr,
had
în
a list of
hotărârea
pending
CSM erau
cases,
menționate
and
56
indeed,
de cauze.
the SCM decision mentioned
În
56 cases.
scrisoarea expediată de judecătoria
But the
Criuleni,
letter submitted by
anexă,
Criuleni Court
au fost
in the annex,
incluse toate cazurile care au fost
they included
pendinte
all
spre
pending
examinare în gestiunea
cases
dumneavoastră
for
între ianuarie
examination
noiembrie
handled by you
2019 și
between
această listă
January and November
includea 25
2019.
de cauze.
And this list
Civile,
included
penale și
25
contravenționale.
cases, criminal, civil, and
Comisia a
contraventions.
examinat în detaliu această listă
The
și
Commission
conform datelor din
looked closely at
programul
this
integrat
list,
de
and according
gestionare a
to the
dosarelor
information from the
și
Integrated Case
portalul
Management
instanțelor
System and
naționale,
according to the National Court
dumneavoastră ați
portal,
finalizat
you
examinarea a
completed
15 din aceste
the
cauze
examination
în
of
2018
15 cases in
și în
2018.
2019 ați avut
And in
spre examinare,
2019,
sau cel
you
puțin așa reiese
examine,
din
or at least this
date,
follows from
doar
the data,
10 cauze.
but you had only 10 cases to examine.
Aceste date cumva vin în
These
contradicție
data
cu ceea ce ați declarat dumneavoastră
contradict
și la evaluarea
your
inițială și la Curtea
statements
Supremă și în răspunsul
made
pe care l-ați
during
dat
the
la
initial evaluation before the SCJ
notificarea
and
Comisiei cu privire la
in your
dovezi
response to the
și fapte și
Commission's
dovezi serioase. Deci am
statement
vrea
of
să facem
facts.
3 precizări ca să ne fie și nouă
Therefore, we
clar.
want three
În primul rând,
clarifications to make
între 16
to
octombrie
understand. First of all,
2018
after 16th of
și
October
1 ianuarie
2018
2019,
and until 1st of January
dumneavoastră
2019,
ați primit, v-au fost
uh,
repartizate
did
cauze
you
noi
still
la
get
judecătoria
new
Criuleni?
cases assigned at
Eu
Criuleni
niciodată nu
Court?
spuneam că mi-a
No,
fost
I
cauze
never
noi
said
repartizate
that
la
I got
Criuleni.
new cases
Eu
assigned in
deja
Criuleni Court.
nu
I
primeam cauze noi.
was not
Pur și
receiving
simplu
new cases,
examinam și
but
veneam
I
pentru
was
examinarea
examining, I
cauzelor
was
care
coming
deja au
to
fost în
examine
procedura mea.
cases
Am
that
înțeles.
were already
Acum, dumneavoastră ați
handled by me.
văzut cauza. Deci noi nu vorbim
So
ce ați
you
examinat
saw it. We're
dumneavoastră
not saying what you
16
examined
octombrie
between 16th of
2018 și
October
31
2018
decembrie
and 31st
2018.
of December
Lista de
2018.
56 de cauze
But
la
a
care
list of
dumneavoastră ați făcut
56
întotdeauna
cases that
referință
you
e
always
lista de
refer
cauze
to
conform hotărârii
is a list of
CSM
cases
din
according to the
16 octombrie
SCM decision of
2018, da?
16th October 2018, right? Yes.
Comisia a solicitat și s-a
The
focusat pe perioada
Commission
ianuarie
asked and focused on the period
noiembrie 2019. Și conform datelor
January to
obținute de
November
comisie pe care dumneavoastră le-ați
2019. And according
primit,
to the data
dumneavoastră în
the
această
Commission
perioadă ați avut
received and you got
25
them
de
too,
cauze
you
pendinte
had
conform judecătoriei
25
Criuleni. Este
pending
corect sau
cases
contestați
according to
acest lucru?
Criuleni Court. Is
Eu
that right?
nu
Or
pot
do you
să
connect?
acum
I
să confirm sau să
cannot
infirm, dar
confirm
acele
or
56
deny that, but
cauze
the
au
56
fost conform
cases were
hotărârii CSM.
as per
Eu
the
nu
decision of the
le-am
SCM.
enumerat după
I did
asta.
not make a
Eu nu
list of
pot
them.
spune dacă asta
Afterwards,
corespunde
I
sau nu
can't say
corespunde.
if
Eu știu că
that
aceste cauze au fost
is
menținute în
correct or not.
procedura mea
I know
și
that these
este evident
cases
pentru
were
mine
kept
că
in my procedure, and
ei
it
nu
is
pot să
obvious
fie
for
mai
me
mult sau
that
mai
they
puțin.
There could not be more or fewer of them.
56
Again, Ms. Rusu, we are talking about 56 cases as at 16th October 2018. But now, in your written answer to the Commission's statement of facts, you said that between January and November 2019, let me finish, my dear, please. Between January and November 2019, you worked in the following way: 3 days in Cahul and 2 days in Criuleni. Is that right? Is the statement correct? Yes, it is. Okay. Also, according to the information gathered by the Commission, you actually, between January 2019 and November 2019, you had only active cases handled in your procedure. So 2 days a week, and you examined 10 cases. I cannot confirm how many cases I had. If you checked and you insist that this was the number, I can only say that there were criminal cases where we planned hearings, and you probably saw the hearings. They were set for those days. You received that list, and you did not make reference to this aspect. That's why we are asking, because it's not clear. Okay, what do you mean when you say that during those months, January, November 2019, you had to spend 2 days a week in Criuleni? From the moment when I was
în situația când examinam și la Taraclia și
in the
la
situation
Criuleni,
that I had to examine cases both in Taraclia and Criuleni, almost every week I was coming to Criuleni for 2 days to examine these cases because I had criminal cases. I don't remember all of the cases now, of course, but there were criminal cases when with witness testimony, with so there are cases when we had hearings planned with several parties involved. Now I cannot say precisely. When I said 56 cases were left in my procedure, and I examined the number I said of cases in Criuleni, I meant the entire period, starting from October, probably, because I did not have it divided, like how many cases I examined starting in January, from January 2019. I did not have that information, and in my answer, I don't remember now exactly how I wrote it, but I would like to clarify now that it was about the period from October and until the moment when cases that were not examined were taken from me and assigned to another judge. Okay, Ms. Rusu, the Commission provided a detailed overview in the statement of facts. This follows directly from the decision of the Supreme Court, and the Commission is obliged to look into it. That's why we will ask an additional question for you to answer this. If you examine 10 cases 2 days a week during 8 months, or how many, from January to November, 11 months, it's probably some lack of clarity. This couldn't have happened. We will send it to you in writing so that we get clarity about this matter. Okay, I don't have any other questions, Chairperson.
Okay. Are there any other of the members of the Commission who have any questions at the moment? No further questions. If that is not the case, then I would like Mrs. Rusu to give you the opportunity to make a brief closing statement at the end of this hearing. So please go ahead.
Da, eu mulțumesc pentru această
Thank
oportunitate
you for this opportunity
să fac personala mea concluzie, da, sau
draw my personal conclusion,
procedurii în care
to make my own analysis of a procedure that I was part of.
să încep
And I want to start
circumstanță care așa întâmplător probabil a
a
coincis.
circumstance that
Azi e ziua
was
tatălui meu,
coincided by accident. Today is my father's birthday. He died 2 years ago. So 28th of June. And he was the one who wanted me to be a lawyer, a judge. And when I started to work as a judge, that was my intention. And he said that the system is corrupt, judges are corrupt. Why do you want to work in this system? Because that's the perception. And I told him, Dad, do you think you brought me up in a good way? You educated me well. Don't you want at least one person that you trust to be in the system? I did not regret it at all. I do not regret taking part in this procedure. I regret only that this preventing procedure, despite the fact that not only myself, but many judges who took part in it believe that this procedure or aspired for this procedure to be fair, impartial, and correct. I have to say that I really have many doubts about it. Unfortunately, decisions that I saw and I read and analyzed, the approaches that I analyzed, leave a lot of room for interpretation, unfavorable interpretation. I heard how candidates were thanking the commission, they were passing the evaluation afterwards, but I thought that if I can find some things for which I could say thank you to the commission, and probably the only thing is that you checked almost my entire life for a 15 years period, my personal life, financial life. You checked, you even checked if you checked one of my scientific papers against plagiarism in this period. You checked for a period all court hearings and cases that I had, and I am sure that any person, legal professional or independent person, could be convinced that could be convinced of my integrity. I am honestly telling you that you believe in my integrity, and it's very sad for me to see that approaches that you have are so different and inexplicable. The entire country and all the people, lawyers who kept an eye on pre-vetting, had some hopes and aspirations that this process would bring clarity. Unfortunately, that did not happen. A lot of criticism, a lot of scandals that we see in this process they intend the doubts that exist. And I would like to say that when we talk about an evaluation that should have been a fair one, when I, or in my case, there have been quite serious interferences with my personal and professional life, I am now speaking of a moment when you even checked whether there was plagiarism in one of my scientific papers. But at the same time, we have situations when some people or a person passed
având cauză
the
penală
evaluation with flying
și nu cauză
colors,
penală
having
pe
a criminal
orice
case
infracțiune,
against them. And it wasn't just
dar
about
numai pe
any
infracțiune de
offense, it
corupere.
was a
Este foarte
corruption case.
trist,
And this
foarte
is very
trist
sad.
că
Very
această
sad that
abordare diferită care
this
noi o
different
vedem
approach
cu ochii liberi,
that we see
mai mult seamănă la,
looks
știți,
more like,
membrii
know,
internaționali poate nu
the
cunosc această
international members
expresie
may not know this
de a căuta
phrase.
not în papură. Eu cred
Oh.
că interpretul se traduce această expresie,
Well,
de ea
word for
înseamnă
word is
de a
for you
căuta
to
ceva ce nu
well, to
există. Este,
to
de
look
fapt,
for something that does not exist,
noi
or to
toți știm că
just keep
tot ce nu
doing
există
in
tu nu
order to
poți să
find something.
confirmi.
The idea is that you
Dacă omul
cannot
este corupt,
confirm just everything that
dacă omul
exists.
este
If a person
neprofesionist,
is corrupt or
asta e
is
ușor de a
not a
dovedi,
good professional, that
dar
is
este
easy
foarte
to
greu de a
prove,
dovedi
but it's very
invers.
hard to prove the opposite.
Și aceste dubii serioase care au
And
fost aduse
these
mie
serious
pe
doubts
acest proces de
um,
pre-vetting,
expressed about me during this pre-vetting process,
eu le percep ca această
I
activitate dintr-un
perceived
punct de vedere inutilă,
this
de a
activity
căuta not
as
în papură.
being useless in a way, just
Dacă membrii
looking
internaționali au venit aici
for the
să
sake of looking.
lucreze
If
și nu
international
cunosc
members are
realitățile,
here
nu cunosc
to
pe
work and
persoanele
they don't know the
care
reality, they don't
evoluează,
know the
eu
people
vreau
that
să vă
they
spun că
are
eu și
evaluating.
alți judecători,
I want to
chiar și
tell
domnul
you that
Pani și domnul
myself and
Chirtoacă,
other judges,
noi
even Mr.
trăim în
Panish, Mr.
această
Kirtaka,
societate.
we are living in
Avocații,
this
procurorii,
society.
judecătorii, colegi
Attorneys,
ne
judges,
văd, ne știu
prosecutors, colleagues, they see
cum
us,
lucrăm,
they know how we
cu ce ne
work,
îmbrăcăm, avem
how we
mașină sau nu avem
dress,
mașină,
do we have a
în ce
car or
casă
not,
locuim. Noi
what
trăim
houses do we live in.
dintre
We are
oameni care ne știu. Și chiar
well,
dacă
it's among
comisia se
people
încearcă
that
mai
we
departe
know.
să abordeze,
And even if the commission is trying to
că eu totuși sunt lipsită
keep
de integritate sau aveți dubii
approaching this from
integritatea
the
mea,
perspective that I have no integrity or you have doubts about my integrity,
oamenii care mă știu și oamenii care
the
au
people
avut
who know me,
posibilitate să
the people who had the
uh,
possibility
vede audierele sau să
to
examineze
see the
hotărârile
hearing, to look into the
Curții Supreme de
decisions
Justiție sau
of the Supreme Court
Curții Supreme, Colegiului
or
al
of
Curții de
the
Apel sau deciziile care
panel
voi
from
le
the Court of
emiteți.
Appeal, or the decisions that
Curtea
you
Liber poate să
issue,
confirme acest fapt.
they can
Că procedura de
confirm that
pre-vetting a fost
easily,
una
that the
selectivă.
pre-vetting procedure was
Părere
selective.
de rău constat asta.
And
Este
I'm sorry
constatarea mea
to
personală.
find that,
Eu vreau să vă
but
spun
it
că
is my
referitor la
personal finding. And I want
nu
to tell
deodată
you
și
that,
confirm și spun încă o dată acest moment. Când este un
well, I want to say this once more, I
lucru
confirm that it
dezbătut în
is
instanță de judecată și
a
este o
thing, if
hotărâre
it's a thing that was debated in court and there is a
în care
decision,
a fost examinat, a fost examinată o chestiune și a fost constatat
so a matter was examined and it was
unele fapte,
found, some things were
prin decizie
found,
revocabilă, asta este
and an
acoperit
irrevocable
prin puterea
decision was delivered.
Constituției.
That is covered by the
Articolul
power of
120.
Constitution, Article
Și eu vreau
120.
să spun că este un
And
drept
I want to
fundamental
say that it
pe
is
care
a
se bazează
fundamental
puterea
right
judecătorească.
judicial power
Și
relies on.
doamna Nina Tzoțoria, Nona
And
Tzoțoria, eu dacă
Miss Nona
cred că
Tzoțoria,
corect am pronunțat,
I hope I
fiind
pronounced it correctly,
judecător la Curtea Europeană, poate
being a judge
confirme
in the European
sau
Court,
poate chiar și examinat
could
unele cazuri când
confirm,
statul
or
a
maybe
fost
she
acuzat
looked into cases, examined cases where the
neglijat
state was accused of
puterea lucru
neglecting
judicat.
the power of res judicata.
Este un lucru foarte grav,
This is
mai
a
ales în cazul când noi
bad
vorbim
thing,
de
especially when we
examinarea
talk about
circumstanțelor
examining circumstances
în afară termenului de prescripție,
beyond the statute
când
of
a trecut
limitations,
mulți ani, mai
when
mult
many
decât
years
termenul
have passed
în care a
more
putea surveni eventual
than
o
the
răspundere
period
disciplinară.
when some disciplinary liability could have been
Eu
invoked.
vreau să spun că când
I want to say that
au fost examinate foarte multe circumstanțe
when
sau
a lot
dezvăluite
of
foarte multe
circumstances were
circumstanțe
analyzed or disclosed,
care am indicat eu și în
and
cererile
that I
mele
declared
de
and in my requests for
recuzare referitor la
recusal or
doamna
declarations of
Raducanu și
recusals about Ms.
președintele Comisiei,
Raducanu
domnul Herman
and
von Hebel.
chairperson of the commission,
Eu vreau
Mr.
să vă
Herman
spun
von
că
Hebel.
aceste
I would like to tell you
circumstanțe
that these
sunt foarte
circumstances are
importante,
very important
deoarece când este vorba
because
de
when you
evaluarea integrității unui
are talking
judecător,
about assessing the
este
integrity of a
extrem de
judge,
important
it's
că
extremely
membrii care
important
examinează,
for the members
evaluează
who are examining,
și dă
evaluating,
aprecierea că
and
se
giving an
bucură de această reputație
appraisal
ireproșabilă.
should really have a reputation above any
Dacă, de
reproach.
exemplu, noi vorbim de
And
eficiența
for
unui
instance, if you talk
judecător, de
about the
randamentul, cum a
efficiency of a
examinat-o,
judge, about the
corect, nu
performance
corect, care sunt
coefficients, did you examine it
consecințele,
correctly or not?
este
What were the
foarte
consequences?
important.
It's very
Și
important
membrul comisiei
for
să
a
nu
member of a
aibă în
commission
spatele un scandal
not to have
internațional
an
care a
international
fost reflectat
scandal
în presă
behind themselves that was
internațională
covered in
referitor
the
la
international media
ineficiența
about
unei implementarea unei
inefficiency
reforme
in
care s-a
implementing a
soldat cu
reform that ended
prejudiciu
up with
de milioane.
damage
Eu
worth
înțeleg,
of
doamnă
millions.
Nadejda, că
I
în față văd
understand,
că nu
Miss
sunteți de
Nadezhda.
acord cu
I
tot
see
ce
your
spun.
face and that
Dar
you
asta nu
disagree
numai
with
eu
everything
spun
I'm
asta.
saying, but it's not only me saying that.
Asta a văzut toată lumea.
Everyone saw
Și
that.
chiar dacă
And even if
domnul președinte comisiei consideră
chairperson
că
believes
lumea este
that
bucuroasă că
the
el
people are
prezidează
happy
această comisie
that
și
he chairs this
face
commission
vetting-ul
and
corect,
carries out a correct vetting,
nu e așa.
that's
Foarte multă
not
lumea,
true. Many
juriști,
people,
avocați,
lawyers,
procurori,
attorneys, prosecutors,
au adus foarte multă critică intimată. Comisia
had
de la
a
Veneția
lot of
tot a adus foarte multă
justified
critică
criticism,
legislației.
and the Venice
Avem
Commission
rapoarte
also criticized the
internaționale care au fost
legislation a lot,
făcute pe
and there
prevetting,
are international
care tot
reports
conțin
on
foarte multe
pre-vetting that
precederi.
also include many clarifications.
Eu înțeleg că nu este plăcut să auzi
I
tot ce eu
understand
spun
it's not
acum.
pleasant to
Este
hear what I'm saying now.
un discurs care este
This is a speech
emoțional, personal,
that is
dar participând la această
emotional, personal,
procedură
but
care m-a
being
afectat
part of
foarte
this
mult,
procedure that affected me a lot.
eu nu pot să fiu
I
100%
can't be
100% obiectivă. Eu oricum sunt
100%
subiectivă.
objective. I am subjective in any way.
Și dacă este vorba de
And
ce aștept eu de această evaluare, vă spun
speaking of
sincer că
my
nu aștept
expectations
să
related to
fiu
this evaluation,
promovată.
I don't expect to be
Probabil
passed.
că din cauza abordării care
Probably
am văzut.
because of the approach that I saw.
Probabil că din cauza
Probably
tuturor
because
circumstanțelor care au apărut.
of all the circumstances that happened.
Dar asta nu are importanță. Pentru mine este
But
important
this
să
is
au
not
posibilitatea
important.
să rămân așa cum eu sunt. Să fiu
What
sinceră,
matters for me is to stay as I am,
inclusiv și
for
cu
me
voi.
to be honest with you, including
Să
that,
țin minte
to
că
remember
integritatea mea
that my integrity
este un lucru care nu
is
poate să fie schimbat
a matter
prin o
that cannot
decizie.
be changed
Ea
by
ori
a
este,
decision.
ori nu este.
One either has integrity or not.
Thank you, Mrs. Russo. I think this will bring us to the end of the hearing of this resumed evaluation that, as you know, the Supreme Court of Justice instructed us to take. With that, we thank you also for all the submissions and answers that you gave. And we will, as per usual, withdraw for deliberation. And as much as possible, the Commission will strive at delivering a decision within a month after the date of the hearing. I declare this hearing closed. Thank you very much.